Hi, welcome to Victory IAS and another session on important bills. The next bill is the Multi-State Cooperative Societies Amendment Bill. You might know what is a cooperative society. It is nothing but a group of people will give contribution, pay contributions, and they spend this money for farming, credit, development, etc. So these cooperative societies work under democracy system, municipality panchayats. Okay, in that cooperative societies will be there. So for the development of cooperative multi-state cooperative societies amendment bill has came up. What is the ambition of the bill is that to make cooperative societies more transparent, to work selflessly without any selfishness. The cooperative societies must work. Generally what happens, if a group of people form a cooperative society, whoever the leader is there, the funds will be with him. There is a chance that the leader can misuse the funds, or he can act on biased basis. That's why to make the cooperative society more transparent, new bill has came up in Lok Sabha. That is, the Union Cabinet approved Multi-State Cooperative Societies Amendment Bill seeks to amend Multi-State Cooperative Societies Act 2002. Already whatever the act is there from 2002, that is being amended now to make the society more transparent and reliable, to bring transparency in this sector and reform electoral process, and also to change the electoral process of the leader of a cooperative society also. These amendments came up. So multi-state cooperative societies is cooperative society with objects to serve interest of members in more than one state. So they serve in the interest of the members. Suppose one person want credit, they can take from the society and he can repay in installments. Okay, one person want help for his farming, then the society will give. Like that, it is for the welfare of the society members. So the MSCS Act was passed to govern such cooperatives whose members and areas of operation are spread across more than one state. They are cooperative societies spread in one state and more than one state also they spread over. Like you might know Amul India. It is nothing but a cooperative society, but it works in multiple states. So like that. At present, India has more than 1500 multi-state cooperative societies. Now India is having more than 1500 multi-state cooperatives working all over India. So what is the need for amendment now? To strengthen governance, reform the electoral process, improve monitoring mechanism and ensure ease of doing business in multi-state cooperative societies. To make them more transparent and reliable, and to change the governance, electoral process, how the leader will be elected, that process also will be changed, and monitoring the process of mechanisms, how they work, and ensure ease of doing business. Means whatever the transactions happening in the multi-state cooperative society are prompt and time to time they are happening in reliable way. That is the objective of this amendment. So to improve the composition of boards and ensure financial discipline, besides enabling raising of funds in multi-state cooperative society, and also the composition of boards will be should be reliable and handling funds should be reliable. It's must not be like that the leader is misusing the funds or any member is misusing the funds. It should not happen like that. So there should be some sort of financial discipline in the cooperative society. That's why the amendment has came up. So it incorporates the 97th constitutional amendment which provided constitutional status to cooperative societies in India. So there is one amendment in the Constitution of India, that is 97th amendment, that has given constitutional status to cooperative societies in India. We will also discuss whatever the amendments related to cooperative societies here. So, constitutional provisions regarding cooperative societies. 97th Constitutional Amendment Act of 2011. The right to form cooperative societies is a fundamental right. So, anyone under Article 19, anyone can be a member of a cooperative society, or anyone can stand in the election of cooperative society. And new directive principles of DPSP, on promotion of cooperative societies, Article 43B. And under DPSPs also cooperative societies has been mentioned under Article 43B. Okay, a new part 9B to the Constitution is titled the Cooperative Societies, Article 243 ZH to 243 ZT. Now means another part 9B of Constitution, in which the cooperative societies also mentioned under articles 243 ZH to ZT now. So under these articles the amendments has came up now. Okay, so the 97th Constitutional Amendment, the bill incorporate provisions of 97th Constitutional Amendment, improve the composition. It also the bill want to improve the composition of the cooperative society. It seeks to improve the board and ensure financial discipline, and rising of funds also changed now. So the process of rising funds also changed now, enabling the rising of funds in multi-state cooperative societies. Okay, so the rising of funds process also will change with this amendment. Article 91(1)(c), the word cooperatives was added after unions and associations in Article 19(1)(c) under Part 3 of Constitution. So in through Article 19(1), the cooperative societies word has been added in the Constitution after unions and associations. So what is Article 43B here? That is added by DPSP Part 4 regarding promotion of cooperative societies. This is for the development and promotion of cooperative societies in each and every state of India. And creation of new Ministry of Cooperation. Also a new Ministry of Cooperation has been established to monitor the activities of cooperative societies. Okay, separate ministry has been established which gave more acknowledgement to cooperative societies. So if one cooperative society has to be established, they have to take the permission of this Ministry of Cooperation. Okay, once they took the permission, they can establish the cooperative society, and whatever the transactions happening within the society, they have to inform to the Ministry of Cooperation time to time. If they need any sort of help and feedback also, in that time this ministry will help out. Okay, the aim of the recently approved legislation is to rationalize role of multi-state cooperative societies and increase their members' participation. This is done to increase public faith in these institutions. Why amendment is needed? So that they should not be given so freedom, so that they are not reliable, not transparent anymore. Corruption is going to happen in that. In that case, what happen? In a democracy, a democratic body, okay, multi-state cooperative society is corrupted, then public will lose faith in it. Okay, the public will lose faith in it. They feel joining a multi-state cooperative society is a waste because they are always corrupted. It will not work out anything. We don't get any help. So to stop this, the government has given some amendments to the original bill. Okay, in order to realize this goal, the legislation seeks to boost transparency and accountability and improve governance in reliability, accountability, and to improve governance in the multi-state cooperative society and financial discipline and fundraising, etc. things. These amendments are suggested. So what are the key amendments here? Okay, setting up of to improve governance, reform electoral process, strengthen monitoring mechanisms, enhance transparency and accountability. These are things till now we discussed. Okay, so to improve the credibility, transparency, financial discipline, fundraising, all these things, and to keep public faith, amendments in multi-state cooperative societies are being suggested. So they insert a new section related to establishment of cooperative rehabilitation, reconstruction and development fund. They also want to establish one new fund in cooperative societies, that is Cooperative Rehabilitation, Reconstruction and Development Fund for revival of sick multi-state cooperative societies. For those societies who are in loss because of their past activities, for them a separate rehabilitation, reconstruction, development fund. It is like a reconstructive bank. You might be at the bank of reconstruction in economy. Like that, one fund has been established. Insert section relating to concurrent audit for multi-state cooperative system societies with annual turnover or deposit of more than the amount as determined by the center. There will be concurrent audit will be conducted in multi-state cooperative societies, so that there is to ensure there is financial discipline within the society. Okay, the merger of any cooperative society into an existing multi-state cooperative society. So small cooperative societies will be merged to make a multi-state cooperative society that is operating between different states in India. Okay, means those operating within a state, small societies, they will be merged together to form multi-state big cooperative society. Okay, to establish a cooperative election authority, and also they want to establish a separate election process. Separate election process. Like you might be some municipality election, okay, state assembly election is different and Lok Sabha, Rajya Sabha elections are different. In the same way, they want to conduct one separate election for cooperative societies, so that the leaders will be elected by the people transparently. Okay. So cooperative election authority will ensure that elections in cooperative societies are conducted in fair, free, timely manner. So an election body, cooperative election authority, like Election Commission of India in lines of Election Commission. But Election Commission is very big. It operates all over India. But these cooperative election authority, it also operates all over India. But it take care of only cooperative societies operation, not state elections or municipality elections or anything. Okay, so they bring electoral discipline in amendment. What is the ambition of this electoral body? To conduct fair, free and timely manner elections in cooperative societies and to bring electoral discipline. The bill proposes barring offenders for 3 years. It also means banning. They ban offenders who did false practices within the cooperative society for around 3 years. Okay, to appoint one or more cooperative ombudsman. This is for dispute readdressal. Dispute readdressal. Suppose within cooperative members some dispute has came up, they can come and complain in this ombudsman. This ombudsman is nothing but to complain on corruption also. Corruption or any illegal things are happening within the society, they can give complaint on this. With territorial jurisdiction, they will have a territorial jurisdiction, means some state people can only come there and complain to the ombudsman. In another state, one more ombudsman will be established. Means it will operate to a particular territory only, not outside the territory. Into inquire into members' complaints. The cooperative, I told you that whatever the complaints, disputes are there, they can give complaints here to ombudsman. So they will resolve, inquire into members' complaints. The cooperative ombudsman will provide mechanism for redressal of grievances. Whatever the grievances are there, complaints are there with the members or leaders or corruption, anything that they will inquire into that and they can solve the problems also. Members in an organized manner. To make provisions for the appointment of cooperative information officer. Okay, one more officer is being established now. That is cooperative information officer. Cooperative information officer will increase transparency by providing access to information to members of cooperatives in timely manner. This is nothing but under RTI. RTI Act, if any member want an information, they can proceed to the cooperative society and they can access the information. In order to boost ease of doing business in sector, the legislation proposes to shorten registration period. And the amendment wants wants to shorten the registration period of cooperative society to make it more transparent and easy for business transactions. It allows applicants to see extra time of 2 months to rectify mistakes. In case of any mistakes are there in establishing a cooperative society, they can take 2 months extra time. It digitizes the submission and issuance of documents. All documents related to cooperative society will be digitized. Okay, and this information will be available online, so that any seekers can go into online website and they can access the information. For that, to manage this online thing, an information officer will be and office will be established. The bill proposes inclusion of co-opted directors with experience in the field of banking, management, cooperative management and finance in the board of multi-state cooperatives. Whoever the information officer is there, he will be from banking, management, cooperative management fields. He will have the relevant experience, then only he can manage the cooperative easily. To boost funding for multi-state cooperative societies, the bill has provisions for issuance of non-voting shares. Okay, it also has issuance of non-voting shares also. Those who do not vote any shares, that shares will be handled by this officer. Okay, and the fund will be available to the multi-state cooperative society also in critical times. Rehabilitation, reconstruction, development fund will be set up to revitalize struggling cooperative society. This already I told you. The bill seeks to increase accountability of multi-state cooperatives by improving the auditing mechanism. Auditor will be established. So, fund will be established, rehab fund will be established. Okay, cooperative ministry will be established. Audit has been introduced to make the cooperative societies are working in transparent manner. And number 4, election authority will be established. Ombudsman will be established to take care of disputes and complaints. And number 6, information officer will be there to give information on lines of RTI Act. Okay, so federal issues concerning the bill. What are the federal problems arising here? No provisions of constitution makes way for merging cooperative society which is incorporated under state law with multi-state cooperative society. So we discussed that different state cooperative societies can be merged and can give rise to big multi-state cooperative society. There is no constitutional provision for this. Even though there is no constitutional provision regarding merger of multi-state cooperative societies, the center want to interfere into operations of multi-state cooperative societies by this class. Means the center is indirectly encroaching on rights of state cooperative societies through introduction of clause concerning the merger. Okay, they want to interfere in the operations of multi-state cooperative society by this clause, merger clause. Okay, so beyond the legislative competence of union, as state cooperative societies are within the exclusive jurisdiction of states. Even though the center interfere, the multi-state cooperative societies will be under jurisdiction of state only, more compared to center. Okay, this is all about multi-state cooperative societies, friends. So let us now move into the next bill, that is the draft press and periodicals bill. So government will revive registration of press and periodicals bill for new registration regime for newspapers. This is, the bill is mainly for newspapers. Press Act you might be heard of. Okay, Press Act in times of Britishers, they used to keep some control on press so that the nationalism will not spread all over India. In the same way, after our government, independent government formed after 1947, they want to keep some controls on the press so that they do not monopolize, they do not get so much money, so much power, so that they can control the government. That's why this draft press and periodicals bill will be introduced. is introduced and will be amended time to time based on the requirements of the government. Okay, so it will include digital media as well. This time this is including the digital media as well. Digital newspapers like Hindu Times of India, whatever, they will be coming online also. On that also the bill is mentioning some controls in this. Okay, the current registration framework does not include digital news. Whatever the act presently is there, it does not include digital newspapers. It will replace Press and Registration of Books Act 1867. Now these 2024 Act is going to replace 1867 Act of Press and Registration of Books Act. Okay, that regulates newspaper and printing press industry. So till now, since our government formed, there is only one amendment regarding newspaper and printing press. That act since 1867 not amended. So for that the amendment came now. So what is there in this? It will enable central and state government to formulate appropriate rules or regulations for issuing government advertisement in newspaper, accreditation of newspaper and such other facilities for newspapers. Means suppose the government is printing an ad in newspaper, then the center or state can give regulations regarding the ad so that the newspaper can't mislead the people in wrong way. Okay, the regulations will be given by the government only. So create a press register general along with laying down a simple system of registration of e-papers. Okay, there will be press registration general along with a simple system of registration for e-papers. Means there will be registration process for e-paper and press register general for general papers. It is mandatory for editor of the periodical to be an Indian citizen. The editor of a paper must be an Indian citizen. He can't be a foreigner. So allows anyone who is a citizen of India to bring out its publications, and they can bring out their publications freely. There is no force or there is no control on the publications anywhere in India. The bill seeks to punish the concerned only with a fine. The previous bill has fine plus imprisonment, but in case they given any wrong news regarding the government, now with this act they can only give the fine, but they can't give imprisonment to the editor. Okay, seeking public comments, India's I&B ministry issued draft rules for implementing Press and Periodicals Registration Act passed recently. The rules outline for the press register. So the bill seeking public comments, India's IB ministry should draft rules for implementing Press and Periodical Regulation Act. Okay, recently Information and Broadcasting Ministry has been issued some rules in new act, and it is passed recently. It outlines the powers and processes for the press registrar also. Along with editor, registrar also, the rules has been drafted. So inspection triggers media houses. Means inspection can be done in media houses now onwards. As per draft, physical inspection of publisher business premises can be taken up if annual statements are not submitted regularly and a desk of audit flags is issued requiring further verification. In case of they are not submitting annual statement properly, or there are doubts to the auditors that they are getting so much money, means they are having huge profit, then they can directly visit the media house to inspect. Okay, press registrar's discretionary powers. What are the discretionary powers here? Okay, the registrar can also initiate inspection after receiving complaints about a publication or if deemed necessary for other exceptional reasons. Apart from visiting, they can inspect also. Inspect the things also there. Okay, justification for the same has to be recorded in writing. So whatever the press register or editor are submitting a justification to the government, they have to make a statement, written statement over it. Okay, verification of circulation claims. And whatever the, if they tell, suppose 1 lakh papers are daily circulating in the public, but they will tell only 50k. In that case, verification can be done from the machines, print machines, how many papers are publishing every day. So if 1 lakh is publishing every day, means 1 lakh sales are happening. But only if they tell lies also, they can inspect the publishing printing machines in the house. Okay. Another provision enables verifying circulation numbers in if a newspaper seeks central government ads or is subjected to complaints. So if a newspaper is having any complaints in government ads, then they can verify the circulation numbers also like that. Initial checking has been via desk audit of submitted information. Generally, they verify the submitted information. In that case, if they have any doubts, they can inspect the premises of the publisher. Concerns around sweeping powers. Some experts have criticized discretionary physical inspection clauses and giving sweeping powers to authorities with possibilities of misuse to harass media outlets. So, but using this inspection provision, any government official can harass the publisher. That's what the publisher's concern. Even though they did nothing wrong, then also the government going visiting the publisher premises every time, and they can harass the publisher multiple number of times. That is the concern of the publisher here. The Press and Registration of Periodicals Act enacted by Indian Parliament in 2023 aims to replace archaic 1867 press registration of books legislation instituted during colonial rule. So whatever the in colonial rule, whatever the Press Act is there, that is amended now here. It was formally implemented from December 29th after getting legislature approval and presidential assent. So legislature approval means here 2/3 majority voting, and presidential assent also required on the bill, then only it can be circulated all over India. 156-year-old Press Act was criticized as an absolute legislation lacking required oversight mechanism for digital age media platforms. So the old act can't do anything with digital media, but now this bill has included the digital media also. By repealing and introducing updated provisions governing registration of publishers and norms compliance, the 2023 Act seeks to catalyze responsible journalism, curb misinformation proliferation enabled via modern technologies. Okay, they want to track how journalism is working inside India, whether they are giving the right information to people or not, whether they are misleading the people with wrong information. That will be verified by this Press and Periodicals Bill. So our next bill is Uttarakhand Uniform Civils Code Bill. Uttarakhand government introduced legislation to implement Uniform Civils Code. Means Uniform Civil Code is nothing but law is same for all people. Okay, rules are same for all people, like that. Okay, it enacted Uttarakhand would become second Indian state to adapt UCC after Goa. Okay, after Goa, Uttarakhand is the only state who has been adapted this UCC bill. Every time I can't say Uttarakhand, every time I can't say Uniform Civil Code, friends, I will use the word UCC. Please follow. Okay. So the Uttarakhand government is likely to table UCC bill in upcoming assembly session. Okay, they have placed this bill in 2022. The UCC bill passed by state assembly has received president assent, making it a law. So finally, after passing in the assembly, it has been given the president assent and making it a law. Uttarakhand is the first state in India adapt to UCC after independence, and this is the first state after Goa to adapt to UCC after independence. So UCC committee finalizes draft. The UCC drafting committee formed in June 2022 held extensive public consultations. It claims to have received over 2 lakh written submissions and met 20k people. So whatever the UCC bill came up, that is not a discretionary decision of government, but the people has given 2 lakh people were asked opinions and 20,000 people has given sign to the UCC bill, then only it become a law in Uttarakhand. So the final draft focuses on issues like gender equality, uniform property rights, adoption rules. So gender equality, property rights, adoption rules, baby adoption rules are changed with introduction of this bill. So currently being printed before being tabled in the assembly. UCC aims to provide equal rights to all citizens. What is a uniform civil code here means equal rights to all citizens, curb the oppression of women and promote social equality. This is actually I can't say like this, but this shows very disgusting, or it is like very joking thing that already there is no oppression on women all over India. Equality has come up after independence. People are living freely. Although why they need a bill, that I do not understand here. So without logic, just we have to follow what is the bill, how it is implemented. That's all. Providing equal rights, it is common. Everyone is having equal rights inside India. Oppression of women is not there like before independence. And social equality is everywhere. Even the low sections also given equality everywhere in the society. Then why there is a need for a bill, that I don't know. Whether Uttarakhand is having that much oppression of women or social inequality, that we have to discuss separately. Okay, just we have to follow here what is the bill, that's all. So the objective of UCC bill, the bill aims to eliminate discrimination, arbitrariness in civil laws based on religion. In Uttarakhand, people feel like it is a land of gods. So there will be more caste feeling between people. So there should not be discrimination and arbitrariness in civil laws based on religion. Okay, caste feeling should not show everywhere in the state. In essence of Article 44 directs states to provide uniform set of civil laws regarding marriage, divorce, inheritance and adoption. Property, inheritance, marriage, divorce and adoption for all citizens irrespective of their religion. With religion, these laws should not change. Marriage, divorce, adoption laws, property, inheritance laws must be same for all caste of people inside Uttarakhand. So the concept of UCC aligns with the principle of one country, one rule applied equally to all religious communities. So equal law should be applied to all religious communities. For high caste, the rule should not be like one thing. The low caste rule should not change. For all caste, rule must be the same thing. Indian Constitution explicitly mentions UCC in Article 44 under DPSP. So the UCC has been mentioned under Article 44 under DPSPs. The article states that state shall endeavour to secure uniform civil code for the citizens throughout territory of India. So the article states, Article 44 under DPSP states that the state shall endeavour to secure UCC for all citizens throughout India. By this provision, that UCC has been introduced into Uttarakhand also now. So, through leaders like Nehru, Ambedkar supported UCC during constitution drafting, strong opposition from religious handliners and lack of public awareness at that time led to include under the non-enforceable DPSP. So at that time, Nehru and Ambedkar recommended UCC, but due to there are differences between Congress leaders, between high caste people and low caste people, that UCC can't be implemented at that time. They want it to be implemented as fundamental right, but it should not happen. The framers hoped that over time UCC will be implemented once social conditions were ripe. Later they thought that after the world has modernizing after independence, automatically the UCC conditions will come over. But in some places still it is very backward. People can't live with equality. That's why Uttarakhand government has to introduce a new UCC bill into their government. So the proposed bill aims to regulate and govern laws relating to marriage, divorce, succession, living relationships and adoption. The bill specifies prohibits bigamy, polygamy practices that involve marrying multiple people simultaneously. So the bill opposes bigamy or polygamy, means simultaneously one person can't marry to several people. are while still legally married to another person. UCC bill also outlines 5 specific conditions for solemnization of marriages within the state. The UCC bill also mentions 5 particular conditions for marriage in the state of Uttarakhand. Okay, key features. What are the main features of UCC here? We have to see that is ban on polygamy, means multiple wife or multiple husband culture must be stopped. Child marriage must be stopped. So this is bill is backward, or I do not understand. This is we will discussing only. Just you have to follow what is the bill. That's all here. So child marriages are almost over all over India, that we all know. But why Uttarakhand is implementing a particular bill? Whether child marriage is prevalent in Uttarakhand state, that we don't know here. Just we have to blindly follow what the bill is here. That's all. The draft UCC includes complete ban on practices like polygamy, child marriage across religions. Standardized marriage age. They also standardize the marriage age for men to be 21 and female to be 18 as per the law of the government. The court sets 18 years as a uniform marriageable age for all girls, enabling them to pursue higher education before marriage, so that if girls got more time to get married, so that they can concentrate on their studies very well. So couples who fail to register their marriages would be ineligible for government facilities to encourage legal documentation. So couples must register their marriage, otherwise they are not eligible for legal documentation. And there should be uniform diverse laws within the state. The UCC envisages standardized diverse laws such as halala and idat. This is for Muslims actually. Halala and idat, that is one type of diverse process. That's why they want a uniform diverse law all over the state. This eliminates differential treatments depending on religious affiliations. Okay, so that diverse process will be same as in Hindus and Muslims. There will be no difference. Equal adoption and property rights. The draft grants equal adoption rights to all citizens irrespective of gender or faith. It also confers equal property inheritance rights for both sons and daughters and adopted biological children. So there should be equal rights to both female, means son, daughter or son, or adopted child must have equal rights on the property of the father. That has been given in UCC bill. In case of death, the spouse, children and parents will have equal rights over the property. In death of a person, his wife or parents or children will have equal rights over the property of that person. Mandatory registration of marriages and live-in relationships. Even live-in relationships must get registration. Otherwise, anything can happen. Suppose a girl can be easily cheated. A girl lives with a boy for 6 months in live-in relationship. After that, if the girl become pregnant, then the boy can easily cheat because it is not a married relation, not a registered one. It is a live-in relationship. So to stop this type of cheatings also, the government is introducing registration for live-in relationships also. Another significant proposal requires mandatory registration of all marriages to ensure legal accountability. Registration of marriages is common everywhere. It is mandatory nowadays. Without registration, inheritance, adoption of property, things won't come to the wife. That's why generally they register everywhere. Live-in relationships would also need to register under new laws. Conditions for solemnization of marriages. There are several conditions for getting married also. Under section 4 of UCC, 5 conditions laid out for valid solemnization of a marriage between a man and a woman. These conditions include: neither party should have a living spouse at the time of the marriage. It should not be like that a man is having already one wife, he can't marry another wife. This is not legal under UCC bill. Neither party should be incapable of giving valid consent due to mental unsoundness, suffering from mental disorder. Suppose a person is not well, should not be married. Because if he is not mentally not well, he will suffer the wife after getting married. That's why that type of people should not be allowed to get married under UCC bill. So rendering them unfit for marriage. So they are declared unfit for the marriage because they can't take care of mentally unsound person. Mental person can't take care of himself only. How he can take care of the wife? So if he gets married, the wife life will suffer. So in that case, the government stop this. The government declares he is unfit for marriage. He should not get married. Okay. So subject to recurrent attacks of insanity. The man should have completed 21 years age and woman 18 years of age. Both the man and woman should be majors. The parties should not within the degree of prohibited relationship unless their custom or usage. The parties should not have any prohibited relationship, illegal affairs or illegal relationships after marriage. However, these customs usages should not be against public policy and morality. So all these rules are according to public policy and morality only. They are not against the public morals. So the marriage should not be prohibited under any existing law. So religious beliefs, practices and ceremonies. In religious beliefs, practices, ceremonies, what are the amendment the bill has been recommending? The UCC bill allows for solemnization of marriages according to various religious beliefs, practices, customary rites and ceremonies. These include but not limited to Saptapadi, Ashirwad, Nikah, Holy Union, Anand Khara under Anand Marriage Act. So Saptapadi means it's like 7 rounds the girl and boy make in the marriage. Ashirwad means they will take the Ashirwad of parents and the pandit in the marriage. Nikah means it is a marriage in Muslims marriage, and Holy Union means it is nothing but Christian marriage, and Anand Kara it is one type of marriage for 6. Okay, so Act 1999, Special Marriage Act. Special marriage is nothing but like intercaste marriage. Two girl and boy love each other, so they want to marry. That is called special marriage. And Arya marriage means one girl and one boy escaped from house, then they can get married in Arya Samaj. So exemptions in the UCC bill. What are the exemptions? We discussed what are the points in the UCC bill has given still now regarding marriages and regarding property adoption and other things. So now we will go into what are the exempted things in UCC bill. Despite its broad base, the UCC bill does not apply to certain groups. It does not apply to certain group of people. Okay, members of any scheduled tribes as defined in clause 25 of Article 366 read with Article 142 of Constitution of India are exempted. So Article 366, 142 tribes, ST tribes included in Article 366, 142 of Constitution are exempted from the UCC bill. Additionally, persons and groups of persons whose customary rights are protected under Part 12 of Constitution of India are not subjected to provisions of UCC bill. Even the people belongs to Part 21 of Indian Constitution also exempted from the UCC bill. That is the main issue here. Despite the UCC has covered many aspects like polygamy, bigamy and other things, child adoption, property rights, etc., marriage, many things, but it has exempted ST tribes belonging to Article 366 and Article 142 of the Constitution and the people belonging to Part 21 of the Indian Constitution. That is the issue here. Okay.